Hi, everybody. Welcome to our third session in USM's inaugural Wills Week. Today, we are talking about assessing your needs with Elena Sallitto, excuse me, Elena. Before we get formally started, because we are still opening the room and people are coming in, if you would just throw in the chat where you are Zooming in from today, if you have a campus that you're affiliated with you want to share, and whether or not you have any plans in place currently. So it's okay to put no. Actually, most people have been doing that, and that's why we're doing this series, so that we can equip you with some of the tools that will make you feel more confident and equipped to actually go and get your plans done. Because as we have been learning, if you've tuned in already, it is very important, if you have certain desires that you don't want the courts to decide for you, it's very important to make sure that you put your own plans in place. So I'm going to tell you a little bit about our presenter, but first, a couple of housekeeping items. If you have questions, and we will try and get to as many along the way as we can, please keep them fairly general in nature. I know you have particular situations, but Elaine is not going to be able to address those today. Put those in the Q&A, and let's just use the chat, if you will, for reactions and just some of the, getting acquainted, saying hi to one another. And yeah, so with that, I'm happy to introduce Elena Sallitto, who's a principal with Stavely and Sallitto Elder Law in Annapolis, where she focuses her practice exclusively on elder law. She routinely provides counsel on long-term care planning, Medicaid planning, nursing home involuntary discharge issues, nursing home and assisted living quality of care concerns, guardianship, financial exploitation, powers of attorney, special needs planning, as well as wills, trusts, and probate. She's a certified elder law attorney through the National Elder Law Foundation, and she's currently the president of the Maryland, D.C. chapter of the National Academy of Elder Law Attorneys, serves on the State Advisory Council for Quality of Care at End of Life. She's also past chair of the Maryland State Bar Association Elder Law and Disability Rights section. And for those of us in the system, we're happy that she's an adjunct professor at the University of Baltimore Law School, where she teaches elder law. She's the co-author of the elder law section of the Maryland State Bar Practice Manual, and also is on, I think, her third edition of Elder Law in Maryland, which is coming out in December. She frequently testifies before the Maryland legislature on matters affecting seniors. Elena earned her JD at Catholic University, Columbus School of Law, and is licensed to practice in Maryland, Washington, Connecticut, and New York. So I feel very confident that we couldn't have had a better presenter for this topic than Elena. And welcome, Elena, and take it away.
Okay. Well, thank you so much, and I'm really happy to be here. I'm going to go ahead and share my screen. Let's see, share, and it always takes me a minute to do this. Okay. I'm assuming everybody can see it. If you can't, then yell. One of the first things I want to do is just kind of give you a difference between an elder law attorney and an estate planning attorney. And the best way for me to explain it is that estate planning lawyers, and those are the people that you traditionally think to go to for your wills, your trusts, and whatnot, their primary focus is on what happens to your stuff after you're gone. So they're focused on maximizing assets going to your beneficiaries. Elder law attorneys, while we do that as well, we're more focused on making sure that your estate plan is structured so that you get the best quality of life that you possibly can, given your resources at the end of your life, when you do meet some of the challenges of aging. So that's really the thing that defines us. But today we're going to talk about estate planning and what that should look like, and what you should be thinking of when you go through this. So there we go. So the first thing when you're looking at an estate plan, and the first thing that people say is, well, I don't have an estate. I've got a bank account, I've got a house, I've got this, I've got it. I don't really have an estate. If you own assets, you have an estate. and you want to make sure that those assets are structured so they best suit your needs, and then they get to where they need to go if you're no longer here or when you're no longer here. I don't think we have an option on that. So the first thing when you're thinking about your plan is to define your goals and objectives. What is it you want to do? All right, so we're going to talk about your estate. We're going to talk about your estate plan. Well, what are your goals? Do you have family members that you need to provide for? Do you want to honor certain charities? Is there tax issues that you might be concerned of? Are there long-term care concerns? Is there anybody with a disability? So those are the kinds of things that you need to think about as you start to put your plan in place. So your goals will change as your life circumstances change. I noticed in the chat that there were a few people that said, yes, they have estate plans, but they want them to be updated. So they recognize that that has to, that estate plans do change as family circumstances change. So when you think about putting your own particular plans in place, you need to think about where you are in your life journey. Are you a young parent? You're middle-aged? Do you have young children? Do you have disabled children? Minor children? In fact, before we got on the seminar, we were talking among ourselves, a few of us, about some of the primary things that prevent people from actually creating plans, and that is the inability to identify the fiduciary. Who is going to be responsible for taking care of things? Like, who's going to be the guardian for your children if you can't be here? And so they're very difficult questions to answer, but this is exactly the kind of stuff that you really need to wrestle with as you're thinking about what your estate plan should look like. So do you have minor children? Do you have disabled children? In my firm, we do a lot of what I call succession planning. If you've got a child with a disability, what's going to happen to that child when you're no longer there to care for them? Who's going to be responsible to take over their care? Where are they going to live? Where's the money going to come from to provide for them? Greedy in-laws, troubled marriages. Those are always problems that you can't foresee necessarily. And they may be lurking in the background. When you do your estate plan, is there the possibility that at some point somebody's going to come in and be in your loved one's ear and say, well, you should have gotten this or you should have gotten that? Maybe you want to recognize sacrifices made by a caregiving child or somebody else, and you want to honor them in a particular way in your estate plan. What about adult relatives who might be unable to provide for themselves? What do you want to do for them, if anything? And always avoiding family disharmony. And this is something that kind of goes both ways, because on the one hand, this is your very personal private estate plan. And it's really nobody's business about what you do and how you do it. At the same time, you do have to be a little mindful of, is there rivalry between or among your children or with siblings or with other relatives? So that is something to think about. Okay, next slide, and nothing is moving. All right, next, let's see if this works. Yep. Okay. So it is your plan. It is confidential, and don't let anyone ever pressure you into creating an estate plan or estate documents that make you uncomfortable. These are very powerful documents, especially the powers of attorney, the financial power of attorney, the healthcare power of attorney. We'll talk about them in a little bit more detail down the road, but these are hugely powerful documents that you need to be very careful as to who you put in those positions of trust. And be careful of downloading forms from the internet. Everybody says, well, it's readily available, and I have, I got this from the internet. It seems to do what I want it to do, so I'm going to go with that. There may be nuances in the law that you might not be aware of, that and certainly there are other ways to distribute your assets, not just through a will. How are the accounts titled? Are there beneficiary designations? All of that has to come into play so you have a cohesive, comprehensive package. Okay, So as you're getting through this, you need to take inventory. What is it you have? Um, what do you own? What are the properties, the bank accounts, the investments, the retirement accounts? What are your liabilities? Mortgages, loans, credit, consumer credit. So you get a complete picture of your financial situation. And then how are the assets titled? Are they joint tenant with rights of survivorship? What does that mean? And that means that your joint account holder is an owner, and that the death of one of the owners, it goes to the other automatically by operation of law. Are things owned T by E, tenancy by the entirety? This is a system of ownership reserved exclusively for a married couple, and it protects those assets from the claims of creditors of either of them, not both of them, but either of them. So this is also an asset protection strategy. Do you have beneficiary designations? Because that's going to be a way for items to get distributed. So what I tell my clients is if the particular asset knows where it's supposed to go at your death, because there's a joint owner or because there's a beneficiary, it never sees the will. It doesn't care what's in the will. It's going to pass outside the will. You can have the best laid plan in the entire world in your will, but if you've got a beneficiary designation, it's automatically going to go to that beneficiary as it's written in the beneficiary designation. Joint tenants automatically goes to the joint account holder. There are separate tax rules for inheriting a retirement plan. So you're going to list those separately on an inventory because these need to be separately looked at. I want to pick up a question. Let's see what I have. How do we get access? Sorry. I just want to check the chat real quick. And I think we're good. So back to that. Next, I apologize. I'm having technical difficulty moving this. All right. Yeah. Okay. Apologies, guys. Technical difficulties. We're back. Do you have assets or concerns that do need special consideration? Are there business interests? Do you need a business succession plan? That's something that's really, really important if you do have that. I know we've had a couple of situations where for some reason their accountants, CPAs have died with no succession plan. And it's left with, oh my God, what do we do? This person was practicing. They had an ongoing business. They died unexpectedly. There's nobody in place to make sure that these things are taken care of. And in one particular case, the accountant died, I think, toward the end of January, just as people were going to that person and giving them all their information so they could prepare the taxes. So it was a scramble because nobody knew what to do, where to go, how to do things. And it was a hastily put together succession plan that we did on our end. But it's much better if you have that at the beginning. If something happens to you, who's going to be responsible to make sure that that kind of thing gets taken care of? Family trusts. Is that something that you are a beneficiary of, or that's something that you are going to be utilizing for somebody else? Inheritances from others. How are those going to be accommodated? Do you have investment properties? That's something that usually requires a lot of management. Who's going to be in charge of doing that? Property in other states is a factor. If you are going to be administering a will, you are going to have to be administering that will in every state in which you own property, because the property is subject to the jurisdiction of that particular state. So if you own property in Florida, or if you own property in Colorado, or if you own property in both Florida and Colorado, now suddenly you're going to have to probate assets in both of those states. In that instance, maybe you need a trust, maybe there's something else that you need to be looking at. Assets in foreign countries is another way to go. Vacation properties, timeshares, all of these require some attention. Pets, absolutely. Who's going to take care of Fido if you're not there? So just to make sure Fido doesn't end up in a rescue somewhere, perhaps you want to look at a pet trust where you designate somebody who is responsible for Fido and you give them a certain amount of money for Fido's care. Just something to give you some security. Guns are now a special thing, and we have gun trusts. So if you do have guns or a collection of guns that are registered or not registered, this is something that does require special attention as well. Health issues. Always, 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 you want to take a look at what your health concerns are, because that's going to help us in the short term, as well as long term. And here is where this gets a little sobering. But 70% of people who are 60 years old and older are going to need some type of long-term care. Men, an average of 2.2 years, women, an average of 3.7 years. And this is not covered by insurance. Depending on your age, maybe you want to look at getting long-term care insurance. For some of us, myself included, beyond a certain point, the long-term care gets a little too expensive, long-term care insurance. So we're going to look at other ways to manage what that long-term care is going to look like for us. Most likely, we're going to have to self-insure, or we're going to need to leverage government assets. I don't know. Be careful if you hear about these 5-year Medicaid asset protection trusts. It's something that's being touted by many of my colleagues. Sometimes they are appropriate, sometimes they are not. The costs can easily outweigh any benefits. And something that's important to note when you do construct these plans, trusts cannot own qualified retirement accounts. So if the bulk of your assets are in a 401k or an IRK or IRA or 403b, you're not going to be able to effectively utilize a trust. So just be careful of that. Right. Okay. Other factors with health. What about mental health issues, developmental disabilities, or other diagnoses? How are we going to manage that, both for ourselves and for someone else? So if we ourselves have mental health issues and we are looking about creating an estate plan for ourselves, meaning a holistic plan to make sure that our needs are covered, as well as who gets what at our death, maybe we want to look at a mental health advance directive. That's something that would give us the ability to tell other people how we want to be treated in the event that we have an episode. People with developmental disabilities, how are we going to manage for them? Traumatic brain injuries, how are decisions, or how is that person going to be cared for? Certainly there is now what's called supported decision making. So that's a new tool that's available in Maryland, specifically for people with developmental disabilities or a TBI. So in lieu of guardianship, let's look at that. What about special needs trust? So if we do have somebody with a disability, is a special needs trust something that is something that we're going to want to incorporate in our account? ABLE accounts, that's another tool as well. And like I had suggested, the advanced directive for mental health. So these are all things that you really want to take a look at. So when you do assess your needs, you're not just looking at what your financial assets are, but you're also looking at the healthcare needs of both yourselves and anybody else that might be dependent on you. Okay. And here is where things get a little dicey. This is where it gets very difficult. And this is where the clients that are in my office come up usually stumped, either because they don't know who to name, or what we're seeing quite a bit of is people who don't have people to name, and they're not sure what to do. So your beneficiaries, start there with who's going to inherit your assets. So once you're gone, once you've spent all the money you're going to spend in life, you've taken the cruises, you've eaten all you've had your meals out, you've done your trips. At the end of your life, after your bills, your debts are paid, and you have that residuary amount that's going to go out, who do you want to inherit that? Family members, friends, charities, organizations. It's up to you. It's entirely up to you as to who gets what. And be very specific about what each beneficiary should receive. Also, tangible assets. Tangible assets is something a little bit different. It's what you can feel, touch, see. It's your jewelry, it's your cars, it's your yachts, it's your planes, it's the art on the wall. Who's going to be getting that? Is it something you're going to put in the will? Is it something that you're going to do some kind of side memorandum about to take care of that? So something to think about. And again, remember, you don't do these plans once. You're going to keep revisiting these plans as you go through life's changes. Uh, so as you're thinking about who's going to be inheriting what, do you have a blended family? Who's going to inherit at the first death, at the second? Do you want to coordinate the estate plan for both people? I've seen estate plans for a blended family where they go, okay, they'll have a couple come in and they say, all right, everything's going to go to my surviving spouse. And then at my surviving spouse's death, it goes to their heirs. And the spouse, the other spouse says the same thing. Everything goes to, my surviving spouse, and at their death, it goes to their heirs. And I point out, well, okay, if you're going to do that, you realize that at the first death, their children are going to inherit nothing because you get everything, and then everything is going to your children. And they go, no, 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 that's not what we want. That's not what we want. So you have to rethink that. So, so you may need to coordinate estate plans if you've got that kind of blended family. Do you need a trust to protect certain beneficiaries, children from a first marriage, or a beneficiary with a disability? And what about tax considerations for certain classes? Domestic partners, not everybody needs to be married to enjoy some of the advantages of inheritance laws and taxes and whatnot. But if there is a domestic partnership, that's something that needs to be registered in order to gain those advantages. So typically, if you've got someone who's not a spouse, who's not a child, a grandchild, there are going to be inheritance taxes associated. This is unique to Maryland. So if you have a domestic partnership and that's registered with the Register of Wills, then they're going to say, oh yeah, these people had this special relationship, so we are not going to impose inheritance taxes on them. So something to think about too as you go through this. And also just in terms of just talking about who's going to be your beneficiaries. Are you giving taxable shares or taxable interests away? Or not. And if there are taxes that are associated with the distributions, who's going to be bearing those taxes? The estate, in which case everybody who's benefiting from the estate is going to basically subsidize that person's inheritance, or are they, the inheritor, going to pay their inheritance taxes? Also something to think about. And so that's goes all part and parcel with the planning. So it's not so simple as, well, yeah, I've got this and that, and I'm just going to give it to this person and that person. You really need to do some heavy duty thinking on what you want to have happen for the people that you are benefiting, and what is that going to look like, and the best way for that to happen. Selecting the appropriate executor or personal representative. And that's the person who's going to actually administer your estate. Regardless of whether you're doing it in a trust or you're doing it in a will, at your death, someone has to be responsible for marshaling the assets, for making sure that your bills get paid, that your creditors are satisfied, that your estate is kept intact, that there's no waste, there's no dissipation, and that the beneficiaries all get treated the way they are supposed to. Your personal representative, your trustee, if you have a trust, has a fiduciary responsibility, not just to the beneficiaries, but also to your creditors. They have to make sure that those creditors are going to get paid, and that all of your debts are going to get satisfied. So who should that be? It's a job with a specific skill set. So you need to think about it in those terms. A lot of people say when they're choosing who's going to be the personal representative or the trustee, first off, they have this mistaken idea, or at least the named fiduciaries have this mistaken idea, is that, well, I've got all the power because I'm the personal representative or I'm the trust administrator. They don't have power. The power that they have is to carry out your wishes. That's the only power that they have. And it's a job. It's not an honor, it's a job. So when you're choosing the appropriate person to do that job, you want to make sure that they have a skill set appropriate to the job. So you're not going to give the job of being personal representative to the oldest child because they're the oldest child, or because you don't want to offend someone. That's the last thing in the world you should be doing. You need to be matching the job with the skill set, and that's what dictates who the right person is. So don't go, well, these are my people, and this is what I'm going to have. It's going to be, what's the job that I need to have done? And then say, all right, who's available and who best suits those needs. So the job of the personal representative, like I said, you're going to marshal the assets. You're going to make sure that they are kept intact. So if there is a home that needs to be distributed, or, as part of the estate, who's going to maintain the mortgage, who's going to pay the taxes, who's going to keep the lawn mowed, who's going to make sure the sidewalks are shoveled. That's what goes involved in that. So who's the right person to do all that? It's not necessarily going to be, the oldest child who lives off in Timbuktu, who really can't be bothered with making sure that the house is being kept intact. It might be child number 3 who actually lives here. So they have to be organized. They have to be good with money. They have to be able to keep accurate books and records for obvious reasons. And they have to be willing to communicate with the beneficiaries and the heirs. I find that when the personal representative is transparent, to a degree, not everything always, but at least somewhat transparent with the other beneficiaries, it makes the administration a lot smoother. Also, how many other people, a lot of people will say, all right, well, I've got 2 children and I want them both to be the personal representative, the executor, the trust administrator. And you go, okay, fine. But the 2 children can't agree on what day of the week it is, and they will punch each other out to prove that today's Wednesday versus today is Thursday. That's not a good candidacy for the 2 people to work together. I know our office was involved in one such situation. It was 2 brothers, and we actually, they were co-personal representatives, and we had to schedule the time for them to each go to the bank to sign a document that had to be signed on that day. They couldn't speak to each other without getting into a huge fight. So we had one brother scheduled in the morning to go to the bank. And once that was done, then the other brother came in the afternoon to sign the documents and go to the bank. And it was such a headache to get that done, and added a lot to the expense of the administration, unfortunately. So when you're thinking about who the appropriate person is to administer your estate, if it's an adult, if it's children, remember, you're not there anymore as the referee, so to speak. You're gone. And all the worst traits that are possible are going to be coming out after your death. So just something to think about. Okay. Let's see. All right. Let's talk about minor children. This is really, really tough. And I have to confess, I was saying that earlier today. Back in the day, when I had young children and I was married, my husband and I kept looking at each other going, okay, we've got these young kids. We need a will. We need to designate the custodian to take care of the children. And we could never agree on anyone. So we ended up with the default plan was, well, we're not going to die until they're at least 18. Luckily for us, it worked out, but it is really not the best way to do that. So this is tough. This one is really tough. So who is going to be the appropriate person to take care of your children, your minor children, or your children with a disability when you're not there? And tough call, like I said. Obviously, there's somebody who's going to be reflective of your values, and they're going to be someone that is going to also carry out what your wishes are for this particular children. So you need to understand too that there's a lot of flexibility in these documents as you create them and in your estate plan, and you can provide a lot of instruction for whoever it is that's going to be stepping into this very, very crucial role. So for minor children, You're going to be setting up some kind of trust, either a standalone trust, or you're going to be putting a trust in your will. And you can put the provisions in there. They're going, okay, I want my child to have this kind of education, that kind of education. I want them to be able to develop these interests, or whatever interests that they do exhibit as they go on. So it's not just, who's going to be responsible for my child. It's going to be really who's in the best posture to carry out our desires and wishes for our children to grow into the people we hope that they would become. And here's the money that's going to enable you to do that. So it's more along that line rather than who's going to be guardian. And as I'm talking to you about it, I'm thinking, if I had had that kind of advice way back when, I think it would have been a lot easier for me to say, oh yeah, I want this one versus that one, because it's not really who's going to be taking care of your minor children, but rather who's going to best carry out your desires as to these minor children. Who do you trust to do that? How are you going to provide for them financially? That's definitely going to be in some kind of trust. So you're going to have to expect, you're going to have a trust. You are not going to just give your minor children a potload of money, and which would go into a custodial account until they're, I think, 18 or 21, and then they have it. You really want to think about how you're going to structure an inheritance so it allows them to grow into the person that you're hoping them to be. So you would possibly, with instructions, say, okay, to the trustee or the guardian, I want the money spent for this education, or, for this purpose up until their age 25. At age 25, they can have some money outright, but still, I don't want them to have everything. So I still want you to have a little bit of control until maybe they're 30. And then they can have additional money at 30. And then finally at 35, they can have all of it. So you really do have a lot of ability to structure how you want your assets spent long after you're gone. So it's not just an estate plan that you go, okay, here it is, everybody gets this, and I'm done. It's no, no, no. How are we going to provide for the people we need to actually provide for? If you are further on in life, you're doing this and you're a little older, and your children are grown very solidly on their own, and you have no qualms, you've got no issues, then yeah, of course, outright distributions to them. But if the children are younger, yeah, maybe not so much. And maybe you can make sure that, your assets are being spent wisely. Before I go on, are there any questions about this? Because we're going to go a little bit into other areas, and I'm not quite seeing the chat very well. Anne, are there questions that I should be addressing?
Sorry about that. Yes, we do have a couple. So which is best, joint tenants with, was it right of survivorship,
Right,
or
survivorship.
or TBE for a married couple?
Oh, that's easy. T by E for a married couple
Uh,
is absolutely. It's a form of ownership exclusively reserved for a married couple, and the whole object is to protect the marriage assets.
okay,
So while it's subject to claims from creditors of both people, it's not subject to the claims of creditors of either one. So it's very protected.
okay, great. Someone wants to know, would you include timeshares in your estate plan?
Maybe. Yeah. Yeah. No, actually, if you have a deeded timeshare, yeah, something has to happen with that.
Okay,
Yeah. So either you can a life estate deed if you can, or you just will them to someone. Absolutely, you
okay,
need to do that.
great. Another question, are there ways to set up the estate for the estate to hire someone to act as the executor?
You don't hire somebody. Executors are entitled to get paid. They're entitled to commissions. You can appoint like a law firm, very
Mm-hmm.
frequently will get appointed to be that fiduciary for you. But or you can just have your personal representative, whoever it is you designate. They always have the ability to hire somebody.
Hmm. And having done that personally myself for my aunt who didn't have a house and had a fairly simple estate, I absolutely hired an attorney because it's a lot of work, especially if you're doing it for the first time. Um, yeah, get help.
Yeah, it can be. It definitely can be.
Yeah,
This
yeah,
is not an
yeah.
honor. This is a job.
Yep, yep, I agree with that. And then the final question we have right now is if you have a trust for your children, but the person you left in charge of the trust passes, so that would be the trustee passes, who designates who takes over? Do you pick a backup person or do they? So I guess if they're deceased, I don't know how, or you mean the children. So yeah, I think that's talking about like, do you name a couple of successors in case one does pass, or you can actually decline, right? Can someone decline being a
Oh yeah.
trustee? Yeah.
This is It's not involuntary servitude. Um, it's always a good idea to have a couple of backups. The trust itself will tell you, or should tell you, what happens in the event that there's no trustee that's there. Like what we put in our provisions is that trustees can appoint their successors if there's nobody else set. Generally, if you get into the situation where there is no trustee, no successor, and there's no trustee to appoint a successor, then generally the majority of the beneficiaries are able to elect, if you will, a trustee. When all else fails, you can always go to court because the courts do have jurisdiction over trusts, and they can designate a trustee if necessary.
Okay. Again, how many backups should we have?
My gosh, it depends. Two, I mean, this, a primary and a backup is like, I like to see that at a minimum. This way you always have somebody. You can't always plan for everything. And of course, people have limited numbers of people that they can call on.
Hmm.
So yeah, I mean, two backups is nice. I really like, a primary and then two backups is kind of like, yeah, we're good.
Yep. Yep. One more. Let's see. Do 401k funds go to the spouse automatically, or can it be passed to children in the will and or as beneficiaries? So,
Um, yeah and no. There are special spousal protections for 401ks and other retirement accounts. The spouse does not have to take them. And you can definitely leave them to other people, but you're going to have your spouse to buy into that. Um, leaving leaving retirement accounts to your estate so it passes through the will is not a great idea, because a few years ago, probably about 2018, Congress passed a very sneaky tax increase called the Secure Act.
yeah.
And it used to be that if you inherited a retirement account, or several people inherited a retirement account, the payout would be over the lifespan of the oldest person. So you could have a hefty lifespan in which to take that money out. Remember, taking money out of a retirement plan is taxable at distribution. So if I have $100,000 IRA that I've inherited, then every time I take money out, I'm going to be taxed on that distribution as income. So back in 2018, Congress said, all right, well, what we're going to do is we're going to smush the the time frame within which people have to take their IRAs, and they smushed it to 10 years. So for most people, other than spouses, other than those with disabilities, and I think other than those that are within 2 years of the age of the decedent, everybody else has to take that within 10 years. So that's the maximum amount of time that it can be spread out. So you want to make sure that the way this gets transferred goes to allows the person to take the maximum stretch, if you will, in terms of taking it out. If the IRA or retirement account, if the beneficiary is the will, is the estate, then the IRS says, well, we're only going to let you take it out over 5 years instead of 10 years.
Mm.
So yeah, so you really have to be careful with that. And then if you've got somebody with a disability, they can take it out over their entire lifetimes.
Yeah.
which is very nice. So
Yeah.
those have to be specially treated.
Yeah. No, and they're also heavily taxed because they're tax deferred. And so
Yep.
speaking from a charitable position, if you want to make a bequest or a gift to a charity, the traditional IRA is often the best benefit. I mean, the best asset to
Yeah.
use because, of course, charities don't pay taxes. So, yeah. Okay, we have a couple more, and then I'll let you get back to your PowerPoint. And this one comes up every single day. Can you give us a rough estimate of what it costs to create a will for someone with a fairly simple estate, one mortgage, no spouse, paid off vehicle, no minor children, and a modest amount of assets?
No. That's the short answer. No. No, I mean, I hate to give the traditional lawyer answer, but it depends. It does. It depends. It depends on what is it you're doing. And I know you say it's a simple will, and yeah, and the other answer is, well, there's no such thing as a simple will. When we do our documents, we put in special needs trust for the benefit of the spouses because of long-term care issues. We want to make sure that assets are protected from the possibility of a Medicaid payback. So, we do that in our wills. And then generally estate plans, wills are not done in a vacuum. They're going to be done along with somebody's going to look at your beneficiary designations. You're going to need an advance directive. You're going to need a financial power of attorney. And we do disposition of remains. What is that you want to have happen to your body after you're gone? For us, for a single person, we generally start that whole package at 2,000. And we're not the cheapest, but we are definitely not the most expensive. Trusts are going to be a bit more. A married couple planning is going to be more than a single, not as much as a single times two. So there's some efficiencies if you're married. Um, I don't know. I that's I think the best I can tell you. I can tell you what we do, but I can't tell you what other people do. I just know that we are not the cheapest, but we are definitely not the most expensive either. I think we're pretty much in the middle of the pack.
Yeah, I think that sort of aligns with what we heard yesterday from another attorney. All I can tell you is that the cost of not doing your plans could be so much greater than, it's like something else. It's a cost of being an adult, right? You have to pay your taxes and your car insurance and so forth. I mean, it's just something you really need to do. Um,
Yeah,
yeah.
I was on the phone with somebody earlier today talking about estate plans, and they asked me how much it was, and we were talking about this whole special needs trust stuff. And I gave them a figure and they went, "Oh." And I said, "It's less expensive than the guardianship you might need if you don't do the planning that you need to do today."
Right. Right.
Um, so you just have to look at it as an investment to make sure that all your needs are taken care of.
Hmm. Yeah, absolutely. I think you already, there's another question about how reliable are the DIY will creation services. Yeah, so that's the
Um,
answer.
yeah, and I really do hate to say this. I cringe when I see them because people think, oh yeah, because all I have to do is take care of, it goes to my spouse and then everything goes to the kids. And which is fine as long as you stay healthy and nothing ever happens to you. It works. But if you get sick, if you need long-term care, then this is the worst possible thing you could have done. Because what you're doing is if one of you does need long-term care, the other one dies, and somebody's in a nursing home on Medicaid, you've managed to make sure that your spouse in the nursing home on Medicaid inherits everything. And once
Hmm.
they inherit everything, it's going to go to the state. And is that
Yeah,
really what you want to do? So, yeah, no, I mean, you really, really do need to at least get a consult with a lawyer
yep,
about what it should look like.
yep. I completely agree. Someone asked about the typical cost for updating a will and trust. I think, again, that is really going to depend on what you need done. Is it a minor codicil or is it a complete new plan? So
Exactly.
it depends. And then someone was asking a question that I think is really not really in your wheelhouse. Is it better to have retirement 401ks and such taken out pre-tax or post-tax? I think you need to get a financial planner and an accountant to help you figure out your situation.
Yeah.
So, yep. Okay. All right. We have expired all the questions. And so if you want to keep going, we'll encourage people to put more in, but let's get back to the presentation.
Okay, good. And I think our timing is good too. All right, so we are going to move off the wills, the trusts, that, and let's talk a little bit about getting the documents in place for you right now. And this is, everybody needs it. I don't care how old you are. If you're over the age of 18, you need the documents that we're about to talk about. The first one is your healthcare directive, and that is who's going to be making healthcare decisions for you if you cannot make them for yourself. If you are competent, and competency is fluid, you may be competent for some things, but not others. As long as you are competent in terms of what the specific decision is, then you are always going to make your own healthcare decisions. What happens if you're not? Who's going to be making those for you? And that's where these healthcare directives come into play. Now, in terms of whether or not you need a lawyer for what this document, that document, this is the one document you do not need a lawyer. I would suggest go download it off the internet. Sometimes some of the questions are a little complicated or confusing. So I do spend a lot of time with my clients explaining, all the various details of what the document says. But I mean, basically, you are appointing, designating someone to make those decisions for you if you cannot make them for yourself. So here again, we are going to get into, well, who's that person? And you got to look at it. It's a skill set. You're hiring them for a job. You don't do this because this is my oldest child or this is my youngest or whatever it is. You don't do that. It's your proxy has to know you well, has to be able to advocate for you to make sure your wishes are carried out and not push for what they think would be in your best interest. If you don't have this document, then what happens is there's the Healthcare Decisions Act that designates a hierarchy of people who are going to make those decisions for you, if you can't make them for yourself. And they may not be the person that you want. It's going to be your spouse. It's going to be your parent. It's going to be an adult child, all your adult children. And that may not be a good thing. It will be your siblings, if there's nobody else above that. And then lastly, it's going to be anybody who knows you well, as long as they can provide an affidavit saying that they know you well. So I think it's always a good idea for you to have this healthcare advance directive where you designate the people in a priority list as to who's going to be making those decisions for you. And it's not always your spouse. It's not always your child. It may not always be your parent. If those people are the ones that can't let you go, maybe you don't want them as your healthcare advocate. And it's not also about the end of life decisions. Your healthcare advocate is the one who's going to be with you through the whole journey of healthcare decisions. It's not just pulling the plug. It's all right, what about this surgery? What about that surgery? What about this treatment? What about that treatment? And so you want that person who's going to be there to be with you through that whole journey. Your job as the principal is the person who's creating the document, is to make sure your advocate is guilt-free and is not second guessing themselves. So it's on you to make sure that your advocate knows what you want, and that's going to change as life goes on. So it's not a one and done conversation. It's going to be a conversation that happens over many, many years. It doesn't have to be a big, heavy duty conversation. It can be simply, don't ever do that to me. I don't like that. I don't want that. I know I was the healthcare advocate for my dad at the end of his life. And he just said, Elena, after some particularly difficult time he had, he said, I'm not going back to the hospital. Don't ever want to be in the hospital again. I just don't ever do that to me. And when he was 93, his doctor, and he was in assisted living, and his doctor said, oh my God, he's got to be in the hospital for this. She talked to my dad, and my dad said, I'm not going. And so she came to me. So obviously, my dad was out of his mind. He was old. He's got dementia. He needs to go to the hospital. And I talked to her and I said, okay, what is this about? And she explained it to me. And I said, no, he's not going. And she was just appalled and walked out thinking like I was the worst daughter in the world. But I'm thinking, well, he's at the end of his life. What are we going to do? Put him in the hospital. You're going to rotor him. He had fluid on his legs. You're going to send him back to the assisted living. He's going to get fluid again. You're going to put him back in the hospital. It's going to be a ping pong ball. No way to end his life. And it was the right decision. but you have to have somebody who's got the gumption and the knowledge based on what you want to be able to push back against the medical establishment with confidence. So that's your job as the principal, is to give that person the confidence to make those difficult decisions. All right, financial durable power of attorney. This is huge. This is the one where you designate the person who's going to run your money. And it is designating the person who's going to run your money, all your assets. And it's not just your bank accounts. This is the person that's going to sign your tax return. This is the person that can talk to your insurance companies. This is the person that can initiate litigation on your behalf, that can defend litigation on your behalf. This is the person now has access to your digital assets on the financial power of attorney form, whatever those mean. It's huge. It's just huge. So again, who's the right person? They have to be honest, trustworthy, good with numbers, able to keep accurate books and records. So they've got to be organized and good at managing money. You do not want the person who's behind on their taxes running your money. You do not want the person who's getting their lights shut off because they keep forgetting to pay the BG&E bill managing your assets. This is the person that's going to keep the lights on. This is the person that's going to keep the property taxes paid, your taxes paid, making sure that your day-to-day financial needs are taken care of. Again, it's not going to be your oldest child. It's going to be the person who's best able to do that function for you. Another thing you want to do, maybe, is to look at estate taxes. That's something that's been traditionally what a lot of estate planning attorneys have done. Not so much anymore. There are three types of taxes that we run into in estates. The estate taxes, right now it's $5 million in Maryland. What that means is there's no estate tax imposed until the taxable estate means the net estate, the gross estate less the expenses exceed $5 million a person. A married couple can combine that and give up to $10 million to wherever they want to give it to before state taxes come in. I believe at the federal level, it's 12.92 million per person. That's scheduled to get sunsetted, I think, in 2026, and there's talk that it may go down to 7.5 million per person, meaning a married couple then could give up to 15 million without incurring any taxes. In Maryland, our estate taxes are 16%, so it's 16% of every dollar over that $5 million threshold that is taxable. Inheritance taxes, I talked a little bit about that earlier. It's a tax on who inherits. So immediate family members are going to be your children, your grandchildren, your siblings are going to be exempt from those taxes. Your nieces, your nephews, your cousins, your uncles, they're going to be friends are going to be subject to that 10% inheritance taxes. There may be income taxes that are associated with the estate. So if the estate itself, as it's awaiting distribution, earns money, I think it's more than $600, then there's going to be an income tax return, at least, that has to be filed. No gift tax in Maryland, and that's something that is a good strategy. So if you have an estate that's approaching that $5 million threshold and you want to keep that number below the 5 million, people do gifting strategies a lot. Again, this is something that's way beyond the purview of this particular discussion. But if you've got estates that are looking at that level, then it's something that you really want to sit down with a lawyer about, and also with a tax accountant to really make sure that your strategies are such that that's all minimized. And then finally, it's not a one and done. It's what do we do? How often do we look at this? How often do we change this? Because people's lives are not static. You're just not born. You don't just say, okay, I have my will and I'm all good to go. As your life changes, as your family changes, you are going to want to revisit what your estate plan looks like. People are going to come in and out of your lives. Um, People's circumstances are going to change. Divorces, bankruptcies, new dependents, somebody with special needs. So whenever there's that kind of change, you want to take a look at what your estate plan, does it still do what you want it to do? Or do you now need to revise it in a way that maybe will accommodate whatever the change in circumstance is? So here's a note about trusts versus wills. Trusts tend to be a little bit easier to change. The trust can be amended, and it's usually just one page or 2 pages or however long it is to actually amend the trust. You sign by a couple of witnesses, you do a notary, and there you have it. Um, the will has to have a little bit more pomp and circumstance about it. If you're going to change the will, it's just a little more complicated to change. So that's something else maybe that would favor a trust over a will. But primarily, just as circumstances change in your life, big circumstances, moves to another state, divorces, marriages, your children are married to somebody that now turns out to be not the prince or princess charming that you thought they were, and they are going through an excruciating divorce. That's when you really want to think about, let's really restructure this, see what we've got, because we want to make sure that our family is taken care of, not that horrible in-laws family. It's present in my mind because I just spoke with somebody earlier this week about that very issue. So, I mean, that's really it. I was talking about assessing your needs. So it's assessing your needs as they are today with an eye toward that they're going to change in the future. And when you look at things, you need to be very realistic as to what you're looking at. I tell people, look at your family as it is, not as you wish they were. Just take a very hard, clear, realistic look about what you've got and who you've got in your life, and then structure that plan accordingly.
That's great. Thank you, Elena. It's very thorough. We do have a bunch more questions. We have 4 minutes left, so I am going to just go ahead and pick a few that I think apply to most folks. I think a lot of questions about jurisdiction. Someone wants to know how do state jurisdictions factor into estate planning, DC, Maryland, Virginia for healthcare provisions? What if the beneficiaries of the estate live across the country? Should the will be done in that jurisdiction?
Don't worry about your beneficiaries, worry about where the will is going to be administered. So your beneficiaries can live anywhere, doesn't matter. The estate is going to be administered wherever, in the case of a will, wherever you died and wherever the estate is opened up. That's the laws that are going to govern. In the case of a trust, there's a little bit more flexibility with choosing a better site. So if there are better tax reasons to have an estate administered somewhere else, you can put those provisions in a trust and just say, okay, my trustee has the authority to change the situs of this trust to wherever, and may be able to take advantage of more favorable tax laws. So again, it depends on the complexity, who everybody is, where everybody is.
It depends.
It
Yeah.
depends. That's
Well,
the
it's
answer to everything.
everybody's situation is different, so there is
Right.
no rubber stamp. Yep. Quick question. Let's see. How about if you own property outside the country? Can you put that in your will?
Yeah, but I don't think it's going to be much of a, yeah, I mean, it's going to express your interests or your desires as to what happens to it, but to actually change ownership of it, you're going to have to do something in whatever that foreign country is. So we've had this situation come up a couple times, and I always say you've got to get with a lawyer in whatever country it
Mm-hmm.
is, so coordinate what's going on so property passes the way you want it to.
Got it. If you're not married, have one adult child, no will, do end of life decisions and your assets automatically fall to that adult child?
Um, yeah. Um, yeah, actually, so if you don't have an advanced directive healthcare, and you've got nobody else, then that child is going to be the surrogate decision maker under the Maryland Healthcare Decisions Act. The problem, though, is that not all providers honor that or understand it or recognize it. And I have had providers tell children, only children, that they have to get a guardianship in order to make healthcare decisions for their parents. And this poor guy ended up in just a nightmare mess because he got bad legal advice from a doctor.
Hmm.
So just to satisfy the healthcare professionals, do an advance directive. As far as everything else, the laws of intestacy would apply if you don't have a will. And if your only child is your only child, then yeah, they're gonna get everything.
Okay. Quick question. If you move to another state, do you have to restart your estate planning or does it move with you?
Um, wills, trusts that are valid in the state that they are created are valid elsewhere, but sometimes definitions change, and it's always a good idea to get somebody else to take a look at it.
Okay.
Financial powers of attorney are generally state specific. Everybody's got their own form. So you definitely want to revisit that if you move.
Great. Yeah, we just have a lot of questions here and looking through them. We're unfortunately at the hour. Um, Judging by the questions, please go get some good advice on your situations and don't leave it to chance. I think we all either know people or have experienced situations ourselves. Certainly, Elena has taught us many cautionary tales. You don't want to be one. So, you know, um, make sure you get your belongings, your loved ones, all the things you've worked so hard to accumulate in your life, and your own well-being. If you're not able to make decisions for yourselves, just protect it. Um,
Mhm.
so and I just want to make a little footnote. We had a really weird thing happen with the meeting link in the Zoom. So, unfortunately, I know some folks weren't able to join us until late, and some folks just never figured it out at all because I don't know, but like an old meeting link got put in, and we apologize. All of these sessions are being recorded. We're going to send you the links to every one of them at the end of the week so you'll be able to see what you missed. And we're sorry for that. And I hope you have a great afternoon. Please come back tomorrow when we have Malika Moore, who is a licensed social worker, who is going to come and talk about having sticky conversations about estate planning. So that's one you don't want to miss. I know I'm really looking forward to hearing it. So thank you all. Have a wonderful afternoon, and we'll see you again soon. And thanks, Elena. It was great.
I enjoyed it. Thank you.